Oh, that's weird. I'm not hearing anything. What the fuck? Hold on, guys. Ah! Ah, shit. There we go. All right. So we've got visitors. We've got Imani, which is Destiny, and we've got Miss Batroc. So, what do you guys have for us this Sunday evening? Seems like little to nothing. Can you guys hear me? Hello? 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 Can you hear me now? Hello? Testing.
Sean, FYI, we can't hear you.
What about now? Can you hear me? Yes or no?
No.
Fuck. What about now?
I thought you were talking to someone else and nobody was talking, so
What about now? Can you hear me now?
yeah, we can't hear you at all.
Yeah, we can't hear you.
I can hear her, so it's a
Right,
you
hold
problem.
on, hold on. What about now? Can you hear me now?
Yeah, we can hear you now.
All right. Too many buttons on this fucking mic. I accidentally pushed the mute button. All right. So, what do you
Okay.
guys have?
So I actually for Destiny stuff, I wrote out a timeline to kind of just gather myself as to where everything was, and that in itself kind of opened up issues as far
When
as her actual campaign.
when you say issues, what do you mean?
For example, I think I told you last week there were actually 4 X-rays that were done, not 3. So there were 4.
Right.
3 negative and then 1 positive. Well, the timeline, it has gaps. For example, on the day that the child came for the 4th X-ray, apparently there was somebody that actually read it and found that it did not have any X-rays. I'm sorry, any fractures.
Uh-huh.
And then another doctor read it and all of a sudden it did. And this is all noted by time. Also, the child.
Wait. We're talking about the same films. There's an X-ray. One doctor says there's nothing wrong there. Same X-ray later, a different doctor says there's something wrong here.
Yes.
Okay.
I'll go even further. Okay, so I'll give you the well, without giving away the details. What happened is child comes in around 10 o'clock. 11 o'clock they place an order to have this X-ray done. Okay, it was a full skeletal scan for
Can
non,
can
non
can can you move closer to your mic because there's a bunch of echo and it's causing interference and you're getting broken up.
Okay, can you hear me now?
Yep, that's better. Go ahead.
So child comes in at 10 in the morning. The physician places an order for the X-ray, I don't know, let's say 11:30.
Mm-hmm.
They finally do the X-ray at 12.
Okay.
And around 1:30, the physician's assistant that actually ordered this X-ray places a progress note where it says results of X-ray date of service 920
Mm-hmm.
negative for any kind of fractures.
Okay.
All of a sudden, you have this this, I guess, 216. So shortly thereafter, this same PAC gets a secure message from a doctor saying, "Hey, we actually reviewed the X-ray and found fractures."
And who's the new doctor coming in with this new um, finding?
So a
Not
total of
not not by name, but by
I
specialization,
know
area of specialization.
a radiologist.
Okay, so it's just a random radiologist. It's not a child abuse pediatrician.
So it's a pediatric radiologist. However, they are not certified in child abuse,
When you
if that
say
makes sense.
when you say they're not certified in child abuse, what do you mean?
So some pediatricians, some radiologists, even being pediatric radiologists, will get additional training in
Right.
order to recognize and differentiate abusive versus non-abusive fractures, stuff
Right.
like that.
Right.
This specific person ended up being actually a radiation oncologist later on. Remember, this happened in 2021. Now she's actually doing something entirely different. But I
So
look,
hold on and step back a moment. At the time that she is reading this X-ray, was she a fellow or was she attending or what was she? What was her status?
so here's the thing. It was read by two people. One of them is a resident, still is to this day a resident. She just actually graduated the year that she was helping with this case, I guess. And the other person is an actual employee, like she's attending, I guess. Well, I wouldn't say she's a radiologist. They're not, they have them in different
Yeah,
departments.
well, this is the question that I have because and we run into this all the time with the child abuse pediatricians. They always have these residents and fellows working their way through the system. A first year fellow is not capable actually of legally issuing any kind of diagnosis without having their supervising doctor sign off on it. So that's why I'm asking the question is, was this second doctor that did the x-ray, was she a fellow? Was she the supervising doctor? Who is she and why is she involved?
She was a supervising doctor. So
Okay.
the actual x-ray on the bottom says reviewed by, and then it says one doctor's name, that first name, she's a resident.
Okay.
She's a resident at that hospital. She went to that, it's a teaching hospital. She went to that school and now she's a resident, a first year resident.
Okay.
The second doctor is her supervisor.
Okay,
However,
the second doctor is going to be the official finding.
correct. Okay, so that's fine. But that x-ray had already been read by another doctor. This doctor is not a pediatric radiologist, but he's a diagnostic radiologist. And this same doctor was the one that read the x-rays from September 3rd and found that there were no fractures.
And what does he say on this third reading?
He says that there were no fractures, and you know what's crazy? The way he words it was very specific. Like he used words like axial, perpendicular, skeleton, things that I don't usually see. So when I saw that, I noticed that if you go up the timeline on 9/3, he read the x-ray as well. They didn't like his read, obviously, because it was negative. So they brought in these other two, one of whom's a resident, like you said, and then she was, being supervised. But that's as far as the imaging goes. There's a lot of confusion because you have like a negative result, and then the same day within hours, you have
Well,
a positive.
It sounds like there's a conflict in the findings between the medical providers, and that happens sometimes. That there's a conflict. If there is a conflict, either in the warrant application or in the detention report, wherever it is that the agency is going to get approval either prospectively for the taking or after the fact for the taking, they have to disclose the existence of a dispute or a conflict between the opinions of the medical providers. If they do not disclose that conflict, then it's inherently a dishonest report.
So they did not disclose it. But now that you mention it, I'm talking about, x-rays from the 20th of the month. The children were removed the 3rd of the month. That same day that they were,
So all
Yeah.
these x-rays are well after the fact of removal.
they're follow-up x-rays. So whenever you remove a child for child abuse, you do one set and then you do another set 3 to 4 weeks later.
Yeah,
So
claiming that the healing fractures don't actually manifest on an x-ray sometimes until well after the incident. Yeah, I'm
Correct.
aware.
So here's the
I'm
thing.
not sure I buy it, but I am aware of that protocol.
Here's the issue. So on the 3rd, when the social worker claims that she thought the child was having seizure-like activities, so she used that as the sole basis for removal because there was nothing else. The father was out of the house. There was a safety plan in place. On the 3rd, all of the radiology, they did a CT scan of the head, they did an x-ray, everything came back negative for non-accidental trauma. So my question is, if that day everything came back, why did that social worker then call the hospital and say you can discharge home with the foster parents, not the parents? Why at that point were they still
Yeah.
being?
Yeah, that sounds like a decision was made, before the final info came in, and they should have unwound it. It sounds to me like a straight up warrantless seizure,
Oh yeah,
and yeah, that's kind of not. It's not really garden variety because of the medical involvement, but it's pretty close to garden variety. If even if this is the deal, even if the child shows up injured, let's say for example has a severe brain injury, and the parents don't know how it happened. Kids severe injury, parents have no idea how it happened, can't explain it, unless there is some evidence pointing to the parents as the perps, one or the other or both, or pointing to the parents as necessarily having been negligent in causing the injury, there's no basis to take. There's a good case. We did this years ago. It's a published opinion. It's called RC versus Children's Hospital Los Angeles. Kid had a serious brain injury. He sustained it in daycare, it turned out. But the parents, when they were interviewed by the social workers, at least according to the social worker, copped an attitude. So the social worker says, hey, parents don't have any explanation or excuse for how this serious brain injury happened. Fuck them. We're going to take all of their kids. And took them all, and they lost that case. They lost on appeal and got a published decision on it. You can't fucking take kids, even if there is a severe injury, unless there's some evidence to show that the parents somehow were involved in it in some way. At least in the Ninth Circuit. Now, I know that Destiny, she's on the East Coast, different circuit. They may have different rules. But there should be some harmony, at least as to that concept, because it's all derived from Supreme Court case law. So there should be some harmony between the circuit courts or district courts on that.
No, I completely agree. There was one more thing that their own child abuse pediatrician actually testified to that further only made it that much more obvious that the fractures didn't occur in their care, and it was that she dated the fractures having have happened anywhere from, I want to say it was 6 to 42 days. So she gave like a very, very good window. Well, when I went back on that window, before that window even starts, he already had an x-ray. He had an x-ray on August 13th. Just so you understand why this you're probably asking, why the hell were they doing so many x-rays? Okay.
Yeah.
The child is born. I finally figured it out. The child is born, and because the family had a prior case in which they were not found to be the perps and the children, they were never TPR'd, the fact that they had a prior case, I think that's what triggered the hospital to get involved. But they didn't remove him because there was no issue with him at birth. He wasn't born addicted to drugs, no issues. So 10 days after he's born, they come and do a welfare check, which apparently is part of the policy, and they notice that he's fine. Then they get a couple of referrals from an angry mother-in-law, and they basically start following the family close again. And that's how they end up doing x-rays on August.
Did they have consent from the parents to do any of these x-rays?
So remember, she was kind of coerced into going because she said, if you don't take them to the hospital with me to get x-rays, I'm going to take them away. So
Yeah.
I guess
That's an infringement just right on its face.
Yeah, the first two x-rays, I thought I had to because, the caseworker said she would remove the children.
Yeah, that's a coerced cooperation right on its face. That's a 14th Amendment violation for you and a 4th Amendment violation for the kids. Just straight up.
let me write that down. Hold on.
Just send James an email to remind him. But we have a briefing on this exact issue in Pope versus County of San Diego, and I think probably also in Hipschman. And I think Hipschman, I don't know if Pope is on Patreon already or not. I don't remember, but James will know. Same with Hipschman. There's briefing on the motion to dismiss on that. On Pope, I got a summary judgment motion granted against the county. We just settled that case. It was like $500,000 in attorney's fees, and I think like $75,000 to the parents for a coerced consent, basically,
Okay.
on medical examinations or not even examinations, medical procedures. They vaccinated the kid, did a whole bunch of bad shit to the kids.
I think I've seen Hipshman on your Patreon, but I haven't seen the other one.
Hope.
I
Yeah,
think
just shoot James an email, captainsimslaw@gmail.com, and just tell him, and he'll get on me, and then I'll get it to you. I think we just lost Denise.
she'll be back. But that's pretty much what's going on. I feel like with the timeline, it's a lot easier for her to just plug in facts because they're more organized. It's like you have, on this day, you follow the child for 3 consecutive X-rays and you don't see anything, and then all of a sudden,
Yeah, that just sounds fucking weird. It sounds like the kid actually got hurt
foster care.
in foster care, not at home.
Yeah. So I mean,
I mean,
it's
just the timing that you laid out. It sounds to me like the kid got hurt in care,
the foster parent.
which happens all the time, by the way. I mean, you don't want your kids in foster care. Bad shit happens there.
Oh, of course. The foster parents started saying that like the first week that the child was placed with them, he was inconsolable and crying due to his fractures, which really was so strange to me because when he was removed from the parents, he was not inconsolable and
Yeah,
crying.
yeah.
It
Well,
feels like
and then you have to question, when did these reports of inconsolable and crying, when did they start actually trickling in? Because frequently you'll see things where an injury occurs later, and then they go back and they'll backfill, right? And it's actually
yeah.
not real, not true. And now in California, we have a way of tracking that. I was talking earlier about it. It's a program called Safe Measures, and you get Safe Measures matter history and case history reports, and there they actually keep track of when it was that data is put into the CWS CMS case management system. So even though when they print out the delivered service logs, they're in chronological order, you don't know when the data was actually inserted. If you have Safe Measures matter history in hand while you're looking at the delivered service logs, it'll tell you when the data was entered. And frequently, especially when we have like a child death, for example, or a molestation that gets discovered after the fact, frequently you'll see a bunch of backfilling going on. So it'd be like in the delivered service logs, the workers were doing all their timely visits, all their doctor's appointments, everything that they were supposed to be doing on time. But then when you compare it to their Safe Measures matter history, you'll see after the fact, all these things were getting filled in on like a week later on the same day. Social worker figured out, oh fuck, something bad happened. I'm going to get caught. Let me go backfill all my shit that I didn't do. And I don't know about other states if they maintain, that kind of audit trail, but California, it's required. So that's something for the attorneys, because I know that we do have attorneys that participate here, is if you're in California or if you're in another state, that first thing that you want to figure out is whether or not they have something similar to that where they do data tracking so that you can make that comparison. So I'm sure all these people, we know how they work. They fuck up, they don't do their job, then something bad happens, and the first human inclination is to go back and backfill to sort of clean up your record. So I know they all do it. So for those of you that are practicing out there in the world, that's something to look for. And if you're in California, give me a call. Definitely, I can guarantee you that you're going to find shit in Safe Measures that you will not see elsewhere.
Good to know.
Mm-hmm. Yeah, I learned about it from a guy named Jack Anthony. He doesn't do exactly the same kind of work that we do. He does a lot of foster care work. He's got a tie-in with San Bernardino, the Guardian, the public guardian out there. So he does a lot of foster care injury cases. And that's what he does. He just always gets the Safe Measures and then holds them side by side and says, okay, you backfilled all this shit here. This didn't happen. This didn't happen on time. And it's all right there in Safe Measures. You just have to know how to read it.
That's awesome.
Yeah, it's
That's
pretty
awesome.
cool. So lawyer up, you're back. I think that you had dropped for a moment. I'm not hearing you. You need to unmute.
I was having issues with my audio and
It's
my
okay.
camera.
It's okay. we forgive you.
How are you?
All
How's
right.
everybody?
Just busy. Always busy.
Sure.
I don't know about everybody else. They're all muted, but I'm assuming they're okay. So what you got for us this week? Anything? Any revelations? Anything interesting? Any questions?
No, not really. I just came to listen and learn for today.
All right, cool. Well, that's nice of you to turn on your camera. We get to see who you are. That's very
Yep.
cool. All right, well, if you don't have any questions, let's go to Team Austin. He's been sort of patiently waiting.
I don't know about patiently, but I'm always waiting.
Yeah.
I figure that's what somebody they're waiting on you, but I'm actually the one waiting. But I get it. Obviously, thanks.
That's what I tell my wife and kids when they say, "Okay, let's go." I said, "I'm just sitting around waiting on you."
Yeah. That's kind of an ongoing joke with my wife and I. But thanks again for having the show tonight and sharing, your wisdom. And I haven't been on the past 2 weeks. It's been very busy. But going back to what I overheard you guys talking about when I joined, that's the biggest thing I have right now is that besides the person not doing any work and the social worker being out, I have a social worker who returns after the entire review period and signs the court the court report filled with inaccuracies which they withheld from the judge and from me, so I never seen it.
See,
But it wasn't on the doc.
That's another thing just analytically that you have to look at. Recognize that anytime that one of these court reports is filed, it's an official document of either the state or the county, however your programs are administered. It'll be one or the other. But it's an official document. It's provided to the court as evidence, right? So it has an evidentiary purpose, and they know it. So if somebody who does not have at least minimal personal knowledge of the facts set out in that official evidentiary document is signing it and submitting it, then that almost per se is an act of perjury, right? Because they don't know, they didn't do the investigation, they don't have personal knowledge, they didn't talk to anybody, they're just signing this fucking form that the judge is going to accept into evidence and rely on in making his decisions. Now, I think you're in Florida, right?
Yeah, that's right.
Yeah, out in California, I don't know what the rules are in Florida. Every state is a little bit different. We're a basically dual track legal system. We have federal law and then we have state law, and all the states are a little bit different.
Yeah, I'm going in court in Massachusetts as a resident, so it's like they know I'm not there, so they take advantage of me. So that's kind of what's going.
Just recognize what you're going to want to look for. California has very well-defined perjury laws. It's in the penal code. The one we frequently rely on to address this concept that we're talking about right now, that is people signing official documents that are going to be used for an evidentiary purpose when they were not involved in any way in the investigation or the research or anything to create the data to put in this document. If you look at, for example, California Penal Code Section 125, we use it all the fucking time. And I'll try and do it verbatim, but it's been a while. I don't know if I'll remember it, but it says something along the lines of the unqualified statement of that which one does not know to be true is the equivalent of a statement of that which one knows to be false. So what does that mean? That means that unless you tell the reader that you don't in fact yourself have personal knowledge of the truth and veracity of whatever it is you're saying, it's the same as if you were just lying. That's the way I read it. Now the key component there is the unqualified statement, because if you make a qualified statement, and they frequently will do this, it'll be something along the lines of, on information and belief, XYZ is true. Right? Now they have to set out how they obtain that information and belief. They have to say, yeah, I spoke with Joe Blow, the investigator who put all this together, and he talked to all the witnesses, and he informed me that X. Right? So they have to lay the foundation for how it is they obtained their information and belief. But if they give that qualification to the reader, then it's no longer perjury. Absent that qualification, by definition, whatever's in that report will be perjury. So that's something to look and see if Florida has something similar. You might look at California also. There's Penal Code Section 118 and 132. They also have a little bit broader definitions or more specific definitions depending on what you're looking at. but you always want to look at the state definitions for what would constitute perjury in the particular state that you're working in, because the social workers, in making their reports, they have to adhere to the law of the forum state, right? So that's kind of your starting point on your judicial deception claim. Is this lady that signed this thing and filed it? First of all,
Yeah.
did she participate in the investigation such that she would have personal knowledge of the information, or at least the information gathered? And if she did not, is she required to disclose that fact to the court in the document when she signs it? That, hey, judge, I don't know whether this is true or not because I didn't participate in it, but all these people that did do the work tell me it's true, right? That changes the weight of the evidence. If the worker signing it does not have personal knowledge and discloses to the court, think about it as a judge. I'm sitting there, or you're sitting there, and a social worker comes in and says, hey, I did this investigation, or you presume I did this investigation, and this is all the horrible shit I found, versus, hey, judge, I didn't actually do the investigation. I'm giving you second and third hand information that other people gathered. I'm not even sure it's true. You're going to weigh that differently, right?
Yeah, I would assume so, especially, I can tell you, this isn't even case specific, but I'm having a tough time finding precedent for something like this, is that I guess she ends up admitting, but not until, BCF had her on the stand. I was actually attending virtually, and I did have an attorney that day, which was really crazy because I would never pick up on these things. First time I've ever been through a juvenile court or known anybody that's actually.
You just dropped out. You there? Dude, you dropped. All right, well, not sure what to do about that. Maybe he'll be back with us. Anybody else have anything while we're waiting, so that we don't just sit here silently staring into each other's lipid pools?
Like,
I have you're back.
Yeah.
Oh, I think he's back.
Yeah, that's it. No, that was it. Sorry. But that's what happened.
I don't.
Still trying to.
We couldn't hear you the last 30 seconds.
Oh, okay. Well, real quickly, what I was saying was that the social worker eventually admitted that she didn't have firsthand knowledge of the of what had taken place, and she was gone the entire review period. And she volunteered the information. I did not go back and backfill those entries. No, but so yeah, I've heard what you're saying, and I still get to the point I can prove it though. I don't know how to prove it.
If she admitted it, she said, yeah, I didn't have any personal knowledge, and I said this shit. I didn't know if it was true or not. That's an admission, right? Under the evidence code, that's an admission against interest. That's direct evidence of the fact.
Yeah, that's true. She, just like the other one, they didn't recall after that. The next time they were on the stand, I was doing the cross-examination. I asked them the same exact questions. I pinpointed and laid a foundation and was right there. I thought I was asking. They just objected and sustained my questions and blocked me from, I think there was 67 or 70 something objections in one court, the one day of trial that I finally got discovery for. It was a whitewash.
Now, was this in your juvenile dependency case, or are you talking about a civil case that you filed?
Well, civil is next. Civil is on my plate now, and that's it's all I'm concentrating on right now.
Oh,
I have
gotcha.
working towards getting my son.
When did all this happen?
It's still ongoing, but because they're still relying on all this paperwork, it's the same report that they don't even change the date on it. This is the first time I've ever got in 5 years.
All right. Let me try again.
Yeah,
This is a really simple question. Hold on.
Yeah, somebody else can go. I
have a question, and there's a reason I'm asking it.
Okay, go for it.
When did the deception? Let's just stick to that. The deception you're talking about. When did that happen? The first time it happened.
Well, I think it's been going on since the beginning.
Okay.
But
hold on. Give me a date.
Oh, it's the one I'm chasing right now. Okay. It would have been. November would have been the 2-year mark, and then, but it's 3 years here in Florida.
Okay, so you get until next November.
Yes.
All right. Well, get your shit together and get moving, man. Because You only have like what 11 months, not even 11 months, a little less than 11 months left. And I tell you right now, time flies faster than you think, especially when you're working on new stuff.
Yeah, especially when they've got your kid or whatever too. But I'm doing both right now. So, but you'll see it, Middle District of Florida should be coming up soon, and I'll be in touch. But I'd like to let somebody else go just because
Are you? I don't remember. I think you are, but are you on Patreon?
I was for a little bit, and then I got a chance to look at some of the work product, and I thought I'd get a fair chance to evaluate it beyond maybe once or twice. But I've been really trying to. I think I need to set judicial deception. It's a supervisory claim too, because
Yeah. Yeah.
the
Also,
one-
another place that you might look for sort of guidance. They won't really have template or anything you can follow that way, but many of the appellate circuits on their websites, they have forms of jury instructions, and they'll also have a guidebook, a user's guidebook for 1983 litigation. I know in the Ninth Circuit, I mean, that's sort of like our go-to source for new stuff is on their website. We look at their forms of jury instructions, and they don't actually have a jury instruction dealing with parental rights issues, but they have a short treatise, like it's 3 or 4 pages of case law and arguments, discussions, things like that, in their jury instruction booklet. And then they also have a workbook, a work guide for pro se plaintiffs on the Ninth Circuit website for 1983 litigation specifically. And that's an invaluable resource, not just for the pro se plaintiffs, but also for attorneys. Tremendous amount of data, information, research, case law, discussion, how to use it. There's just all kinds of good stuff in there. So, and this is for the attorneys too. Don't be too proud to go look at the pro se materials, because some of that is very, very well thought out and it's pretty good. So, anyway.
I appreciate that. That's good advice. I'll check it out. Nice at the Ninth Circuit, and it's in the learning guides or something like that.
Well, it's not just the Ninth Circuit. I mean, your appellate circuit out in Florida, whatever you guys are, I think like first or second, third, something like that. They'll also have similar resources on their website, and since you're in that circuit, that's a good place to start. I would use that as my first point of departure for my research, is just the appellate court's website, because they deal with a lot of pro se 1983 litigation. So in order to make their job easier, they put a lot of information out there for pro se plaintiffs to sort of follow and go by, and it just decreases the court's workload if people kind of know what they're doing, right?
Yeah, that's true. If you know ahead of time, that's right.
Yeah, so that's why they put it there anyway. It's totally self-interested. They're not really putting it there to help you. They're putting it there to help you to the extent it's necessary to help themselves. So I'd use it. I'd go look and see what's there. Anyway, anybody else got anything?
All right, thanks again, Sean. I appreciate it.
Yeah, absolutely. Thanks for porting in and participating. It's you guys
coming
in with the info and the questions is what makes it work.
That's right. All right, well, enjoy the evening, and I'll be here listening for the rest of the duration. So thanks again.
Yeah, for sure. And Happy New Year, everybody. I think this is probably the first time we've done this after New Year's. I don't remember, to tell you the truth. Maybe we did one on Sunday and I forgot, but I don't remember.
I think this is the first Sunday, right? This is the first Sunday of the new year.
Yeah, okay. There you go. See, I'm getting old.
Gotta get that supplement.
Yeah, my Huperzine A, right?
Yeah.
Not just that supplement. I'm getting old in all kinds of respects. It's falling apart over here. Like.
All right. Well, I'm sorry. Go ahead.
No. Go ahead. I was
just making conversation.
I was just mumbling about my sorrowful existence.
All right. So, I think I brought this up once before, but I kind of wasn't as certain as I am now that this social worker was using an alias.
Mm-hmm.
Is that relevant? And how can I get that during?
Well, it might be relevant, depending on what the purpose was for her using an alias. I mean, was she administering mental health services under an alias?
Yeah.
And under that alias, or actually was she licensed at all to be doing that?
I think she is licensed. I don't know because it's a different name, so it's very confusing.
Well, if it's a different name, then you have to question whether or not she is licensed, right? Have you made a complaint to? Let's see. I think you're New Jersey. Is that right?
New York.
New York. I knew it was New something. Um, Out in California, we've got the Board of Behavioral Sciences. Anybody can make a complaint to them. Do you guys have something similar out there?
I don't know about the Board of Behavioral Sciences, but I made complaints to like Department of Health, HHS, like
Who's the licensing?
the
Who's the licensing
it's
agency there?
Department of Education.
And did you make a complaint to the licensing agency?
I did. I actually made complaints to a bunch of agencies, and I got absolutely zero response.
Did you sue this lady?
Not yet. I'm working on it.
Okay. Well, when is the last event with her?
Probably a couple months, not even a couple months ago.
Okay. When did it start? When did you start? Well, I know you've started having doubts about her like a long time ago because you've been here for a long time, and I remember telling you a long time ago, dump this lady, get away.
Yeah, I mean, it's difficult to discern because I started, in 2020 with her, but she had me so screwed up. Like I was like almost, I don't want to say incompetent, but it was doubting my sanity. She was doing all this stuff and just had me in like
Tizzy.
a twist.
Yeah.
And I
Well,
was like, I would doubt
you're
myself and I would, go ahead.
you're gonna want to be really careful about how you plead this because you're gonna have to, if it started back in 2020, whether you're in a tizzy or not, you're gonna have to deal with the fact of the passage of time.
Right.
I don't know what the statute is out in New York. If it's like California, it's going to be 2 years. It could be, depending on how you plead it, because we get, I think for fraud out here, I don't remember if we get 3 years or 4 years. Let me look it up real quick. Actually,
Well, if I
you.
go for like the easy one, I guess, not easy, but if I didn't know all the information that I know, I could go for medical malpractice, which is 3 years. But there's all these other
Okay.
shit that I have.
Okay, this is something kind of cool. I'll just put the search key in the chat for you, but it looks like in New York for fraud, the statute of limitation is 6 years.
Wow.
So if you could plead it, well, how do you put something in chat? Where the fuck is chat on this thing? Well, maybe I won't put it in chat. Where is that? All right, somebody help this old man figure this shit out. Where's the chat key?
If you hover, wait, I used it last time.
Oh wait, is that it? No, that's invite. God damn. Oh, here it is. Show chat. All right, I found it. All right, right there. That's the search term in Google, and that'll at least get you to the basic info. It looks to me like for fraud, there's a 6-year statute, so you may have that going for you.
Okay.
Let's see what else I have here. Oh, actually, statute of limitations chart. How fucking cool is that? Try this is the link, and that gives you a chart with all the various statutes of limitations. So that'll give your med mal, fraud. I don't know what the straight negligence. Let's see what you have. Emotional distress, negligent emotional distress is 3 years. Fraud is 6. Legal malpractice is 3. Med mal, it looks like 2 years and 6 months from date of the med mal. So I don't know where you're getting 3 years on that, but go look at, because it gives you the statute as well, so you can actually go look it up at that link. But yeah, it has a whole bunch of stuff. Slip and fall is 3 years, so that means the straight negligence is probably a 3-year statute as well. Let's see if it's up there somewhere. I think I might have just passed it. LMN. Huh, I don't see it. Yeah, it's probably 3 years.
Okay, so yeah, that's what I'm talking about how to plead it. If I do all these are all state claims, right?
Yeah, those are all state claims. I mean, we've talked about this before. I don't really see how you're going to get yourself pled into a federal claim. And, but it seems like if you can, your general negligence statute, again, you're going to want to look at this and double check it yourself. But it looks like your general negligence statute is 3 years. So remember, your 1983 claim pulls off of state law for the applicable statute of limitations, and where it pulls off of is only negligence. So, for example, in California, we're a 2-year statute, so anything that you're going to do under 1983, even if you're doing a sex abuse case where there is no statute of limitations, there practically is no statute of limitations out here, the federal law will still look to the negligence statute, even though you're implicating a sexual abuse claim, like under the 14th Amendment or something. You're still going to be saddled in federal court with that 2-year statute of limitations. So be careful about that.
Okay, because I was thinking like, because the alias is connected with the government, like completely connected and intertwined.
How?
So
How? Hold on. How?
okay, it's really hard to explain, but she does work with all these universities and these programs, like this thing called Think College program, and then she does policy.
Hold on. This is the question. Then. Your service with her, was it linked or connected in some way through one of these programs, governmental programs, that outside of your relationship with her she happens to work for? Because, for example, let's say I go lecture at UCSD, so I'm a governmental employee. And then I come out here in my legal practice and I do some malpractice. Just because I happen to have a job with a governmental agency, unless that job is connected in some way to the work I'm doing for you, there is no governmental claim there.
I mean, I believe it is. That's the thing. It's hard to prove. That's how I even found her, kind of, and found her alias, because all the terminology she was using, and about, like I told you, steering the IDD and things like that. So her work has a lot to do with people with disabilities, and that she was really trying to convince me that I had all these disabilities.
Yeah, I'm still struggling with that, and I'll tell you why. If, for example, I don't know, maybe New York County has a therapeutic program for people that are struggling with disabilities, and you went to the county, and the county said, okay, you qualify. Go see this lady who we're going to pay to treat you. Okay, if that were your factual scenario, then I would say, okay, maybe, and it's not even a for sure, maybe you have a nexus where you can plead a federal claim. If that's not the scenario, you probably don't have a federal claim. Now, there's a good case you can go look for. What is it? It's, is it Liston? Fuck, let me go look. I just did a brief on this thing. Hold on.
Sean, what about the fact that, in theory, if this woman was getting federal funding for a project where she was trying to get more developmentally delayed, as she believed, people to be able to attend college, and she, through her practice, would almost convince them that they are developmentally delayed for the purpose of generating income on that project that is federally funded. Is there a nexus? Why?
No, I don't think that's
She's basically recruiting people, essentially.
Yeah,
and trying
but that's grant funding. There's actually going to be no liability, and not only that, but if it's a federal government, then you have to go through the Federal Tort Claims Act anyway. 1983 is not even the right way to do it. But that's besides the point. If she's applying directly to the federal programs, and it's not a grant. If they do block grants all the time where they fund research and stuff like that, it's the research facility that's got the liability, not the grant funder, right? So just because I give you a bunch of money to go study something, doesn't mean I'm liable for the way you conduct the study.
All right. Well, those other ones are really well anyway. The fraud, the med mal, and
Well,
I feel like I have a pretty good case with those.
this is the thing, is she probably has insurance. I mean, it's very unlikely that she's going to be connected with all these projects that have funding and not have insurance. That's like really irresponsible. So I mean, I shouldn't say I doubt she's that irresponsible, because she's doing all kinds of other irresponsible shit. So maybe she is. But anybody acting in a professional capacity with a license, that's one of the first things that you learn in school, is get your frickin' insurance squared away. Now, that being said, I know lots of attorneys who don't carry malpractice insurance because it's super expensive, and they figure, well, look, if I just set it aside each year, what would be the premium, and I don't get a hit for 10 years, I'm money ahead, right? So, I mean, there are guys that do that. They kind of self-insure. Personally, I think that's a very irresponsible thing to do, and I think that it's really kind of stupid. You don't know what's going to happen. Things happen in life, and sometimes you get sued when you did no malpractice at all. So, I'd be surprised if she didn't have some sort of insurance. And frankly, that's going to be your easiest row to hoe.
Okay.
Is just sue her personally, and if she works for a company or worked for a company that was treating you, or while she was treating you, and it was part of her job duties to treat you, job duties for that company, then you sue the company too. But you can't just sue some company because she had a job there if you weren't
Right.
related to her job.
I understand that. Now, what about the I don't know if you call them covert or overt threats? Like, should I include those? Like, don't
Yeah,
poke the bear and all these other things.
yeah. If she made threats to you, and engaged in either coercive speech or conduct, that might go towards a maybe a negligent infliction or emotional, or a intentional infliction of emotional distress. I mean, it starts to sound intentional when she's making threats, right? But you'll have to look at New York, because every state, if you're getting into state law claims, every state has its own version of the common law torts, right? Like, for
Right.
example, California doesn't even allow negligent infliction of emotional distress unless you meet a whole bunch of criteria, which in this instance you would not meet. So keep in mind that every state has different rules when you get to your common law torts. So you'll have to take a look at that and see what's required to be pled in New York. So I have no idea.
Cool. All right. Yeah, that sounds good. Thank you.
Yeah, absolutely. All right. Anybody else? Tatiana, Imani, anybody?
Hey, Sean, I have a quick question.
Yeah.
When you're like suing, CPS, who is their attorney? Like, is their attorney like the state's attorney or the attorney general, or is it like a private attorney?
What do you mean when we sue CPS?
Yes, because for the
So who's on the other side is what you're asking. Who are the attorneys that are defending CPS?
yes, because I had to serve the attorney general and the state's attorney. So I was wondering, are those the same people that fight, like you're fighting when you have your cases?
I don't know. It's going to depend on the particular governmental entity. I can tell you, like in California, the state does not administer the programs. The state has delegated its authority to the counties. The counties administer the programs, and every single county is different. Some counties use their internal county council, and then some counties hire outside counsel. Like Los Angeles, they'll hire outside counsel to defend on our cases. Riverside hires outside counsel. San Bernardino, sometimes they'll do outside, sometimes they'll do inside. Kern County, same thing, sometimes outside counsel, sometimes inside counsel. San Diego is always county counsel. So it just depends. And then Arizona, their programs are administered by the state. They have not delegated their authority to the counties. And every time I've sued Arizona, the Attorney General's office defends. They don't hire outside counsel. So it's really going to depend on the state or the county that you're in, what their proclivities are. and everyone is different. So in your instance, I mean, I really couldn't tell you who you're likely to get, whether it'll be private counsel or, the AG's office. But that's basically my answer. I hope that helped.
Yeah, it helped because I had to, the paperwork that the judge, told me I had to fill out. I ended up filling it out. And so I went on the court rules, and it said, like, if it's a state agency or government agency, I have to serve the attorney general and the state's attorney. So that's what I did. So I was just like,
Okay.
I had to serve both of them. Are those two different attorneys, or are they the same attorney? So I was like,
What was it? What was it again? Is the state attorney general and who?
it was the state attorney and the general attorney. I think it was like two I had to serve. Actually, I can pull it up.
Yeah, pull it up, because the attorney general typically, I mean, that is the state's attorney.
Could have been the assistant attorney general, maybe, because I know in our state we had to serve the assistant attorney general
Oh, maybe.
pursuing the county.
Really, if you're suing the county, you have to serve the state assistant attorney general?
I don't know if she's state or there's no county, right? There's no county attorney general, right?
Well, there'd be county counsel.
No, she was an assistant general attorney, and she said if we sued the county, we'd have to take it to her personally.
That's weird. Yeah, like I said, every state has their own rules. You don't have to do that out here unless you're suing the state of California.
Yeah, that would be kind of awkward too, obviously.
Well, not
if
really.
if it was county.
Yeah.
It was the attorney general and the state's attorney.
Oh, that's weird. Yeah.
I had to serve both of them.
So did you get it done?
Yes, I did get it done. I got it done like last week on the last day that I had to.
Nice. Nothing like waiting to the last minute.
Yeah, I need to stop doing that. I'm a last minute person. I'll have to work on that.
Yeah, it's best to not do that. I tell my kids, if you're showing up on time, you're late. Right?
Yeah.
So get your shit done early, get it together, stay organized. If you're always getting your shit done early, by the time comes to be done, you're not stressed. There's nothing to worry about because you got your shit done. So just keep that in mind.
Yeah. Thank you.
Yeah, I like that though. If you're showing up on time, you're late. All right. Anybody else, or I think that might be it for the evening. Unless you guys just want to chit chat for another 8 minutes.
Well, do you have any cases by chance that are even remotely similar that I could look at of yours, like templates by chance?
Not really to your situation. We just don't do that type of work.
Right.
I think what you're talking about is more in the realm of some kind of medical malpractice or fraud, maybe an intentional infliction of emotional distress, something like that. And it's just, that's just not in our wheelhouse. We don't really do that type of work. Ever since 2009 or so, I used to do a lot of different commercial work and tort work. But ever since 2009, I kind of made a commitment to just suing CPS. And since then, I really have kind of ossified in my thinking.
Oh yeah, actually, one thing I did hear about is like potential evidence I can get is like witness statements. Is that accurate? And if so, do I do that legally, like through a legal format, or I just ask friends and family, can they write a witness statement?
There's a few different ways that you can do it, and it depends on the type of witness. If it's a friendly witness, like friends or family, just get them to do a declaration, and every state has its own rules about what a declaration is supposed to look like, the components that are supposed to be there, the elements of a declaration. Like, it has to be based on personal knowledge, and you have to have testimony in there to affirmatively establish competency, personal knowledge, that sort of thing. So look at the rules, look at your state's rules. Another thing that we frequently do, if we don't have a friendly witness, is we'll serve, say, a third-party witness. A doctor is a good example. We'll serve the doctor with a subpoena. Doctors don't want to come testify. It burns up their day. They don't get paid for it. Horribly inconvenient. So they'll call us on the phone and say, hey, what the hell? Say, well, look, doctor, I mean, this is why I'm subpoenaing you. This is the information that I'm really looking for. This is what I need. And this is what I think you're going to say. Are you willing to put that in a declaration? Or is that true? Are you really going to say this? And if you're not, then yeah, I need to depose you and make you sit down for a deposition and burn your day. Or if I'm right and this is what you're going to say and you're willing to say, would you be willing to just put it in a declaration or maybe even do a sworn interview over Zoom? And they will almost always opt for the most convenient thing for them. So you can frequently get third-party witnesses, even hostile witnesses, to say what you want them to say under oath by hanging the little carrot of convenience out in front of them.
Cool. It's very, very good information.
Yeah, and a cool thing for the attorneys out there and pro se plaintiffs in a federal case is that if you get them to sign off on one of those declarations or do a sworn interview with you, that is non-discoverable work product. You do not have to disclose it to the other side, even if they do a formal request for production. I just had this with County of San Diego where we had this medical. I'm actually sort of proud of myself. I so fucked them on this thing. But I had a bunch of doctors who it was a serious head injury, skull fracture. Mom and dad couldn't tell them how it happened. It turned out that in early mobile infants, it's a common injury when they're like first learning how to walk and stuff. They fall down, they hit their head, they'll get a little hairline fracture. Sometimes you don't even know it. The doctors don't even see it. But anyway, what happened is we have a whole bunch of doctors involved, and we were limited. In federal court, you're limited to just 10 depositions. And that includes parties. And I had like 6 defendants and then a bunch of PMKs. It's more than 10 depots it was going to take to get everybody done. So what I did is I served subpoenas on all the doctors. Predictably, all the doctors called me and said, hey, you're going to have to pay me $750 an hour, 4-hour minimum to come sit for this deposition. I say, well, actually, no, I'm not, because I don't need your expert opinion. I just need your percipient testimony. You'll get your $50 a day witness fee. And then they say, well, isn't there something we can do? I say, oh yeah, sure, there's something we can do. And looking at the records, it looks like this is what you would probably tell me if we were at a deposition. Am I right? And they say, yeah, that's pretty much right. I say, okay, yeah, let's do a sworn interview and I'll go ahead and pay you your hourly rate for 2 hours. And you can do it by Zoom. They say, oh yeah, fuck yeah, I'll do that. So I got their sworn interviews. The other side does not get notice of it. They don't even have a right to be there or ask questions or anything. I asked them the questions I would ask at the deposition, got their sworn testimony, and then told the other side, dude, you're fucked. I've got all this great sworn testimony. And the attorney says, oh, well, give it all to me. I said, no, why would I do that? It's protected work product. So he went and he filed his motion to compel in the federal district court. I filed my opposition, and the judge agreed and said, yeah, McMillan's right. Of course, it's protected work product. You don't get any of it. If you want them, go burn up some of your 10 depositions taking them. And so he did.
I see why. I see why it's protected work product. Okay, I was wondering, well, how could it be?
Also, you know what? There's another one. It's actually a pretty cool setup. Shoot James an email at capsonstemslaw@gmail.com. Ask him for the opposition. Actually, ask him for both the motion and the opposition on the motion to compel the production of the doctor's sworn statements. And that'll give you the whole layup, how it all came about, how it resolved, and how he just had to go fuck himself. Cool. I shouldn't say that. I didn't say his name, did I? I'm not going to say any names.
No, you didn't. You did not.
Yeah, because this is recorded. It is ultimately going to get out there, but I should watch my language on these things. But I was pretty happy about that. I told him what was going to happen. It's like, dude, you're not going to make this. I should ask for sanctions. This is a waste of time. And anyway.
Very smart.
Anybody got anything else? Because I got to squeeze in some dinner in between now and the live stream. James has me set up to do a live tonight right after this.
I have a question. What if I serve the wrong people? Will my complaint be thrown out?
No. What'll happen is the wrong people will complain, and you'll probably have to serve the right people.
Because I was talking to Tatiana, and I think I I served the attorney general and the state's attorney,
Uh-huh.
but I think those are the wrong people now that like Tatiana and I are talking. But I did serve the social workers for like the marshal, so I'm
Uh-huh.
just like worried if my complaint is just like messed up.
Hold on 1 second. What? Yeah, probably 2 more minutes, 3 more minutes. Sorry about that. Yeah, as long as you got the social workers, your complaint's going to be live. Remember, you don't have to get all defendants served in order to survive. You just need some of the defendants served, and then the judge will give you time if you ask for time. You have to ask for time. But if you ask, and you should do it right away, as soon as you discover the mistake, make an application to the judge, explain the situation. I got the wrong people. I got everything done on time, but it's the wrong people. I need more time to go fix this. The judge will probably give you more time to do it. You know, just fall on your sword. Admit there's a problem. You know, he's gonna really bend over backwards to help you because you're a pro se plaintiff.
Okay, thank you.
Yeah, absolutely. All right, guys. With that, I think that's it for the night. I'm getting heralded away for dinner, so thank you all for joining. It was a interesting conversation today. Very cool issues, very lively. That's much appreciated. Makes this thing actually kind of worthwhile. And for those of you that are going to join in on the live, I'll be back in about half an hour.
Thank you.
Bye,
Sure.
everyone.
Happy New Year, guys.
Happy New Year.
Talk to you later.
Bye-bye.
Bye.